We're back in session of cause number 312974. The case is South State of Texas versus Brandon Jarrell Martin. Mr. Martin is before the court on the motion to revoke his probation. There's been a question that has arisen concerning Mr. Martin's original judgment in probation and the extensions, two extensions that was signed extending Mr. Martin's probation. And the court has before it order amending conditions of, well, first of all, the court has a judgment before it, and the judgment states that Mr. Martin was placed on regular probation on September 19th of 2018. And that probation was for 1 year. And then the court also has before it a motion to amend the conditions of that probation. And that motion was filed on July 30th of 2019. And that motion extended Mr. Martin's probation from September 18th of 2019 to December 17th of 2019. And the court has a second amendment, order amending the conditions of Mr. Martin's probation. And this motion, or this order, was signed on November 21st of 2019. And in this order, Mr. Martin's probation was extended from December 18th of 2019 to March 17th of 2020. And the state filed a motion to revoke Mr. Martin's probation on March 3rd of 2020. Okay. Now, Mr. Boyd.
Yes, Your Honor. The new order amending the conditions of probation, which was signed on November 21st, 2019, occurred before that December 17th deadline, which probation would have been terminated at that point, ended. And it looks from the order that it was the intention of the court that was already filed and done before the December 17th date, that the court wanted to extend the probation from the December 18th to March 17th, 2020. And that was the terms, the 3 months from that December 18th through March 17th. And that was all done before that December 17th deadline, setting out the new dates for that extension.
Okay. Mr. Burbank?
I mean, the forms are the forms, Judge, the motions are the motions. I just wanted to make sure that they were timely done.
Oh, okay. Okay. All right. Now, so Mr. Boyd, are you ready to go forward?
Yes, Your Honor.
Okay, Mr. Boyd, you may okay, we're gonna do this. You may call your first witness.
Yes, Your Honor. The state would call Garrett Gilliam.
Okay. You're gonna have Mr. Gilliam to testify from the witness stand?
Sure, Your Honor. You want to step up here?
How you, okay, just hold on a minute. Mr. Porter. Mr. Gilliam, would you, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
You may put your hand down. You can have a seat and adjust the mic. Mr. Boyd, you may go forward.
Please take your name for the record.
My name is Garrett Gilliam.
And how are you employed, Mr. Gillen?
So I work for adult probation, Jefferson County.
And are you familiar with the Brandon Martin?
I am by file, sir.
And were you the actual supervising officer for Mr. Martin?
No, it's not.
And who was the supervising officer?
It's Ms. Reeves.
Mr.
Objection.
Burbank?
If he is not the supervising officer, everything he's going to testify to is hearsay. If he's the only thing he's done was to review a file.
Okay, Mr.
He
Boyd.
has access to those business records, to those files that are kept every day, the same files that are kept from those probation officers. that are in
Let
that
me,
You want to take him on board there?
take him on board there.
Okay.
Good morning, Mr. Gilliam. How you doing?
It is, sir.
Did you prepare the probation file? Where is your probation file? Did you prepare that file?
No, sir, I did not.
Did you put the information in that file?
No, sir.
The only thing that is safe to say is that you just read it and you're here now and agrees to testify.
Yes, sir.
Your Honor, again, I'm going to object that he did not put the record together. He is not then that does not establish him as somebody that keeps normal business records in the normal course of his employment, because he did not put those business records together or the file, and has just basically reviewed, but does not know how it was generated or again, basically put there. And so I'm going to object to any testimony.
Mr. Boyd?
Mr. Gilliam, do you have access to the same information via computer?
Yes, sir.
Have you reviewed that information
Yes, sir.
over your computer? Because you're familiar with it?
Yes.
That's something different. The good question is whether or not basically he's the keeper of the records and whether or not he keeps records in the normal course of the scope of his business. And Mr. Williams testified that in this case, that is not his file.
I don't think that you did not ask that question like that. Whether or not he kept it in the normal course of business. I mean, if you want to ask him those questions to see whether or not,
I can.
Okay.
I thought the state asked if.
I mean, you had him on Bordar, but if not, the state can.
Did you keep that file in the normal course of business?
No, sir.
You know my objection, Judge.
Okay. Motion to remove probation. So your objection was what? Hearsay?
Hearsay, Judge. Well, hearsay, and he's reading from a record or file that he has not put together,
What's, I mean, your objection is hearsay.
hearsay, and that they have not proven that those records, that he is the keeper of those records, and is put as is in his normal course and scope of business. Two of them.
Mr. Boyd, you have a response?
No, Your Honor, just that the probation officer was not able to be here today. I'm trying to.
Well, that and I think the answer.
Well, I mean, I'm just trying to get a response from his, from this case. I mean, you know, pursuant to the Texas Rules of Evidence, section 803C, records of a regularly conducted activity, record of an act, event, condition, opinion, or diagnosis, if the record was made at or near the time by or from information transmitted by someone with knowledge. B, the record was kept in the course of a regularly conducted business activity, or C, making a record was a regular practice of the activity, or D, all these conditions are shown by the testimony of a custodian or another qualified witness, or by an affidavit or unsworn declaration that complies with Rule 90210, and the opponent fails to demonstrate that the source of information or the method of circumstances of the preparation indicate a lack of trustworthiness. So there is an exception, 803 6, but the question is whether or not the state has met the requirements of 803-6, and based on what Mr. Burbank is saying, they have not met that from the testimony that Mr. Gilliam has given thus far. Is that correct, Mr. Burbank?
That's correct.
So your objection will, at this point, will be sustained.
Judges, would the state be allowed to continue the questioning to fulfill?
Oh, yes, 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 if, yes.
Mr. Gilliam, so you're familiar with Mr. Martin, you said? Are you able to?
By previous times that we've been in the court, but have I spoken with him? No. I'm familiar with who he is from being in court this is our third time, and through the file.
Okay. And were you able to review that too, as far as the file, you able to review that on your computer at your office?
Yes,
And did it show, you were able to review the motion to revoke in this case?
yes, sir. I've got that here too as well.
And according to that, and reviewing it on your computer, did it show that Mr. Martin has completed, paid his fees and
Again, Your Honor, before he answers that, I've got to object. He's basically questioning him and not satisfying the requirements of rules of evidence in order to allow him to testify.
Okay, yeah, that's sustained.
And Mr. Gilliam, as far as the files in your office, how is that developed? How is it put together?
The original file at the probation office is created by an intake officer. It's then assigned to which officer handles that case on a day-to-day basis. When it comes to me, I'm assigned the file and given the file 2 days before any hearing that I'm going to be covering under the court that I'm assigned to. So actually, for the last 2 days, I am the custodian of the file until I return back from court.
Okay, and so that's given to you from that officer who has put all that information in those files,
Yes.
and you're not adding any further information to that file.
I review it with the computer, I look at it and make sure that there's nothing missing, so I don't come in and not be able to answer a question, just to make sure everything's that I need is all the questions that I think might come up were answered.
I have a question, Judge.
Yes. You may take him over there.
Thank you. Garen, you are not the keeper of the records for the Jefferson County Community Supervision Department, are you?
I am one of them.
And what is your job duty in keeping the records? What do you do in order to compile the records?
Well, I enter all the information from our visits.
Okay, so let's stop it right there. What did you enter into in reference to Mr. Martin's visits?
Nothing.
Okay, what else do you then do in reference to compiling the record?
Okay, I verify residences.
Okay, and in reference to Mr. Martin, how did you verify his residence?
I didn't.
Okay, what else do you do, sir?
I interview. I'm really not sure what you're asking. I can.
Well,
name
yeah,
about
I mean,
100
did
things
you,
that I
okay,
did.
well, you said something about interview. Did you interview Mr. Martin in the
No,
course
sir.
and scope of your business?
No, sir.
And so that's what I'm trying to, how are you
You're
the
asking-
keeper of the records of that file? I mean, how,
When 2 days ago, when the case is assigned to me to come to court with, that's when I get the file, well, excuse me, the file is brought to me, the paper file is brought to me. And then I review all the information, make sure that I'm prepared to report.
well, I mean, basically, and I'm not trying to put you on the hot seat, Mr. Gillum, but you didn't do anything in preparation of that file. You just looked at it saying, I've got Mr. Martin, for example, today in court, and let me see what the violation is.
And review it for permanent
Right,
substance.
I mean, that's basically, but is it fair to say you're probably not the right person in reference to how Mr. Martin's been on probation since September of 2018? That would have been his probation officer, correct? That would have knowledge of it.
She would have more knowledge than I, certainly.
In fact, you've never even, except for this court and the hearings, and we've been in, recess, so that you've had no contact or didn't even know who Mr. Martin was.
Correct.
Can I renew my objection?
Okay, Mr. Boyd,
And Mr. Gillen, with regard to that, again, you received that file directly from the officer who has compiled all that information in the file, is that correct?
Yes, sir.
In those records? And you don't, as far as that, you don't alter any of that, do you?
No, sir.
Okay. And that's regularly done at y'all's office, is that correct?
Yes, sir.
And Your Honor, the state would just argue that although Mr. Gillen did not compile this, it was given directly from the officer who is the supervising officer, that nothing's been changed in these records. And I think it goes to the, as far as establishing the truthfulness of it and the veracity of it under 902, I believe it was 10 or 11 that you had.
oh, it was 803, 803, 6. Records of regular conduct is an exception to hearsay. Now, based on what I've heard thus far from Mr. Gilliam, I think he said that the records was not made by him, is that correct?
That's correct.
But by a supervisor who is a person or who is someone with knowledge. And two, I think your question, you said that it was kept in a regular course of a regular course of business. Is that correct? Mr. Boyd,
Yes, Your
I
Honor.
think that heard. And then he said that the record was made, was a regular practice of activity in the probation department.
Yes, Your Honor.
So I don't think that the records does not have a lack of trustworthiness based on what's been testified thus far. I think that all of the conditions are shown by Mr. Gilliam, who the court is gonna recognize as a qualified witness. And therefore, Mr. Burbank's motion will be overruled. You may proceed.
Mr. Gilliam. If you reviewed the file from the probation officer, Ms. Rubin,
Yes,
and reviewed the motion to revoke it.
yes,
And as far as under condition 8, was Mr. Martin required to pay a fine, restitution, pay a fine, court costs, probation fees, and also court appointed attorney fees?
yes,
And according to the records in there, you reviewed those,
yes.
did he pay those fees?
He paid some of them, not all. He's in arrears. Right now, I believe it's $1,776. Last payment was approximately 2 years ago. I had to look again.
And as far as Mr. Martin, was he continued on probation?
It was extended twice, the first time with probation fees, the second time without, both for 3 months.
He still owes this 1776.
Correct.
As part of his probation conditions, was he required to perform a community service?
Yes, sir. He was responsible for 60 hours, of which he's completed 30 hours.
You know when he last completed any hours on that?
Yes, the last community service was worked on June 12th of 2019.
So June 12, 2019 was the last time he did a community service.
Yes,
As far as that, was he required to complete a DWI education program as his probation, part of his probation conditions?
yes, sir. And prior to completing it, he must pay for it. Of course, it's $125. That was not done.
Pass the list, Your Honor.
Mr. Burbank?
Now it's good afternoon, Mr. Young. How are you?
Good, sir. Thank you.
Okay, if you didn't know, I'm court appointed.
Yes,
Mr. Martin. That means he doesn't have sufficient funds. Do you have anything in those records of any conversations between his probation officer, Ms. Rubin, in reference to his ability to pay or not pay?
no, sir. No.
Could there have been conversations through your experience, through the probation officer, that would talk about, hey, you got to get your payments done, we've extended it once or twice?
Yes, sir.
Yeah, I mean, that's
Oh,
one of the
certainly.
requirements, right? Are you also of the, through your knowledge of the probation officer, if it is determined that he cannot financially pay all his fees, what usually happens with the probation officer?
Well, we wouldn't be able to make that determination unless he was reporting. And then we could actually, if there was a circumstance where he was reporting, we could perhaps schedule something with the court and let him.
One of the
discuss
things,
that.
yeah, okay, didn't mean to cut you off. There's nothing on here, a violation saying he's paying.
No, sir. But there was a motion to revoke issued and he hasn't reported since. Or hasn't paid since.
Well, how about reporting? You know,
Pardon me?
do you know if he's reported or talked to anybody in probation?
Since the time all this has been going on, well, he has been to court.
No, I'm talking about probation. As a
No, sir, I
report to
don't know.
probation. You don't have any idea
No, sir.
who he's contacted.
No, sir.
And there again, it goes back to really the best person is Ms. Rubin. I mean, because that's his probation officer.
Sir.
Let's go to the DWI. There again, class, which is violation number 3 or condition number 19. The first step is he has to have $125.
Correct.
If he doesn't have that $125, what does your department then do?
That I'm not familiar with, sir.
I mean, if there again, if somebody's court appointed, that I guess determines that they filed an affidavit with the court saying they're indigent. The court has said, okay, you don't have the money for an attorney.
I'd have to bring it to the court.
Yeah.
I mean, I wouldn't have the authority myself to do anything but bring it to the court.
Do you know in that file whether or not anything prior to today, in reference to him being brought before the court saying, hey, you need to get that $125 or whatever it is so you can get into your DWI class?
I don't have records of him
You
coming to
don't
the
have
court
anything
for
like
that.
that at all? Okay. Reference to his community service. What does his record show in reference to community service and where it was done?
Special event at the
Was it for the city of Beaumont?
yeah, this is what I'm confirming for something with the city moving printers and computers at the Women's Center.
And do you have any documentation? You said that he did 30 hours, but he was supposed to do 60. Is there any documentation in there that he was advised that his community service hours were taken care of?
No, sir.
Nothing, you don't know
No,
any
this
comment?
specifically says it's not.
It's not. Prior to today, do you have anything in your file that determines whether or not he is financially able to pay his fines and fees or the $125 in order to take the DWI class?
Only the probation is.
That's what it's.
Okay, Mr. Boyd,
Mr. Gillen, as a part of condition of probation, is it a requirement that probationers maintain gainful employment?
Yes, it is.
Okay, and as far as you know in that file, that Mr. Martin has maintained gainful employment?
No, sir, I do not have that information.
But from September 19, 2018 until today, he has not paid $1,776. He hasn't been able to do that.
Correct. So the last payment that I have, January the 14th of 2020, he paid $42, but since then it's not.
And as far as the community service hours, again, he's had from September 19th, 2018 until today to complete 60 hours, and he's not completed 30 hours of that.
Correct. The last community service hours were June 12th of 2019.
Nothing further, Judge.
okay.
Nothing further from Woodish.
Okay, Mr. Boyd, you have any,
No other Woodish.
okay, Mr. Gillum, you may be seated. What was, let's see, now, Mr. Boyd, it appears that, I don't think this, well, the defense has raised the inability to pay defense. And based on, and that's in reference to the payment of his, the fees that he was required to pay. It appears that Mr. Martin was found to be indigent by the court and an attorney was appointed to represent him. Mr. Gillum has not established or provided any evidence to suggest that Mr. Martin had an ability to pay based on his testimony. So at this point, the only thing we know now is he doesn't have he may have not had the ability to pay because we knew that he was indigent. The court is going to take judicial notice of his file as well. Could you pull up the affidavit indigency? When was Mr. Burbank appointed? That was the most recent one. Let me see. Okay, this was a few months ago. November 13 of 2020. When Mr. Burbank was appointed. So we established that he was in arrears, but Mr. Burbank has put forth a inability to pay defense that has not been rebutted by any testimony that was given by state's witness, Mr. Gillum. Now, in reference to community service, the motion and the judgment shows that Mr. Martin was required to perform 60 hours of community service, and the testimony that was brought forth states that Mr. Martin only performed 30 hours, only half of that community service. There was nothing else that was provided to rebut the Mr. Gillum's testimony. So and just a question now, I think Mr. Gillum testified that as a prerequisite to taking the DWI class, the fee of $125 had to be paid first. Is that correct?
Yes, sir.
Okay, that's the testimony reflected that. So at this point, obviously, Mr. Martin's probation actually expired on March 17th of 2020. So obviously, the court cannot make any amendments to his probation because that time has already passed. So at this point, the court, yes,
Oh,
Mr.
I have-
Burbank.
Well, go ahead, Judge. I'm sorry to interrupt you.
No, you can go ahead on
I
it.
had a possible solution.
You,
In reference to the motion to revoke.
okay, okay,
I'll wait to-
Mr. Porter. Okay. Okay,
Because the motion, because I believe the state hasn't met their burden on the conditions, first and last conditions, because of financial. The only issue is community service. And though I believe that maybe he thought he had finished it, but he's still lacking 30 hours on the record for probation. I would ask the court to recess this for 2 weeks before rendering your ruling on the motion to revoke, and allow him to see if he can do the 30 hours immediately. The only reason why I say that, Judge, is because of what we've been going on in reference to COVID and other things like that, though they should have been before COVID started. It was right in the middle of COVID, starting in 2019. Wasn't it 19 or was it 20?
20, wasn't it?
No, never mind that, but 20, but he couldn't have done it anyway, even when I've got a hold. And so that was my only suggestion, Judge. I agree, you can't modify or amend because it's over with. But to allow, if it's only that issue, if the court was going to say if the only issue was community service, then to allow him 2 weeks or so to come back here and see whether or not he would successfully complete community service. And then you can make a ruling on that.
Okay, Mr. Boyd.
Your Honor, as particularly stated, as a requirement of condition of probation, the defendants to maintain gainful employment, there's no notes in there that showed he doesn't have gainful employment or did not do that. He didn't pay the fines and fees, but as far as the community service as well, Your Honor, he has not completed that. That's been from September 2019 until this date. We've had several appearances, even that was reset from the last time for this contested hearing, and he hasn't completed any of that. The state stands movement at this point is for revocation.
Well, the, you could be seated. I mean, the issue, I think I stated that what's been proven is that Mr. Martin was required to perform 60 hours of community service. It was established that he only performed 30 hours of community service up to 60. It also was established that Mr. Martin was in arrears on his probate, on his, I guess, fines, fees, and costs. And he did not pay the fee for the DWI education class. However, the defense raised the inability to pay defense, that which was really wasn't rebutted. They established the inability to defense. And so the court was inclined to, I mean, we're looking at it from the standpoint of him having an inability to pay. And you, as well as you know, if the person cannot be, probation can't be revoked merely on a inability to pay just for being poor. However, if there's other grounds, and we have at least one more ground, which is the community service aspect. I think the court is going to revoke his probation, but the issue now is what the punishment will be set at. He can get up to 90 days because he has 90 days probated for a year. So, but I think that what Mr. Burbank is requesting is that before the court make the assessment of what his punishment is, then he actually asks for the court to reset the case and come back in 2 weeks and to set the punishment. I think that's what I'm understanding his request is.
That's correct, sir.
And State, you have a response?
Yes, Your Honor. Again, we were reset from last time for a contested hearing. I believe, defendant was aware of that. The state's just requesting that the court, make its ruling with regard to punishment today.
Okay, now let me ask you this here. Normally, and what I've always did and what we did in the past when we had a case of punishment, I've always requested a PSI to get at least get some background, get some punishment information. In this case, I don't know anything other than that he has this case. I don't know if he criminal history. The court does not have that information before it. And then we do know that the court can give anywhere from 1 day on to 90 days. That's our punishment range. We capped at 90 days. And so is there any way, any punishment information can be provided to the court to assist the court at arriving at a fair punishment in this case?
I would recommend, Judge, that I know it's Friday, but next week, Mr. Martin contact Ms. Rubin, if Mr. Gilliam can contact.
Let me do this here. I'm gonna reset it 1 week, okay? And so we'll be back on next Friday for punishment. And at that time, if the state would like to put on any, or the defense put on any punishment evidence, I'll allow I'll allow you to do that. Okay, so we will reset it. But at this point, his probation, the court is, his probation is revoked, but we're going to give you an opportunity to put on some punishment evidence so that the court can make a decision as what the fair punishment would be in this case. Yes.
Would the court consider 2 weeks?
Now, 1 week.
You
Yeah,
know where I'm coming at, for 2 weeks.
no.
This was my previous request, to give him 2 weeks to finish up his.
Oh, well, no.
I don't know if he can get
What?
30 hours done before.
Oh, well, I don't know. Mr.
I would object to that, Your Honor. The state would, believes within a week we'll have the evidence that we need.
Okay, we'll reset it for 1 week. Okay, we'll reset it a week. Set it on Friday. And then we'll be back. Now, Mr. Morton, you still on bond, okay? And so you need to adhere to those conditions. Yes, Mr.
In fact, in relation to that bond, the state was curious as to about the GPS monitor.
I know, I think we've had made
Yesterday.
so you got a GPS? Okay. You have it on you? Okay.
I mean, that's what you booked me in for last time.
Right,
Because I didn't have it, so
Right.
I have it now,
okay,
and I have to pay $225 a month for it.
okay. Well, just make sure you adhere to those, make sure you adhere to the conditions, okay? Okay. Mr. Boyd, you have anything else?
Nothing further from the state, Your Honor.
Mr. Burbank?
No, Your Honor.
Okay, so we'll be in recess on this case until Friday next week. And everyone have a blessed day. This will, all right, this will conclude our calling of our motion to revoke probation docket and announcement docket, cause number, in County Court at Law number